from Paris, he actually stopped in New York and worked on a case, and Isaac Newton, yes, in fact, Isaac Newton, New York County lawyer. But it is a proud tradition, and if you actually take a look at the great legal work that's been done on the cases that are advancing equality for our LGBT colleagues, friends, and family, the legislation that is being worked on around the country, New York County lawyers are all over this, and it's a proud part of our tradition. So Bob, Michelle, Sophia, thank you for continuing the tradition. Thank you all for being here. And as Bob said, and as several people have stated, and will state, I'm sure, as we go forward, this is a particularly exciting moment in this continuation of our great American tradition, because we know that we've made great gains. We've just added 4 states to the roster of states providing full equality. Washington State just this week, and now we have 9 states plus the District of Columbia that confer full legal rights to marriage on all their citizens. But I want to say, as far as the substance of my remarks, that I think it's very important to focus on how quickly this issue has moved, because in my lifetime I've never been a part of anything that has moved as rapidly, that we've seen public awareness and the laws that follow public awareness change as rapidly as we have on this issue. It was only 26 years ago, in 1987, that the Supreme Court decided Bowers v. Hardwick, which said the states had the right to outlaw intimate conduct in the privacy of one's own home, and could criminalize sodomy, make it a felony. The ruling was widely viewed as a setback, but in fact, it's what galvanized the movement for gay rights in the United States. The reaction to it produced extraordinary formation of organizations, organizing activities, one of the largest demonstrations in American history outside the Supreme Court, and freedom and equality became core principles of a vibrant movement that in a very short period of time was to sweep the country. In New York, 12 years later, after Bowers, I joined the New York State Senate, and at that time, in 1999, there was no law in the history of the state of New York that had ever recognized the existence of gay people. And the first challenge we faced was that there had been a bill on violence-related violence, hate crimes bill, that had passed the Assembly each year for 11 years, and had failed in the New York State Senate for 11 years. The reason was made very clear by the Senate leadership. They would pass a hate crimes bill that included bias related to race or ethnicity or religion. They would not pass one that included sexual orientation. This was 1999. So, and to their credit, I have to say, the Black and Puerto Rican caucus in the legislature was offered over and over again a bill that would deal with these other issues, and they refused and said, we will not pass a bill that leaves out sexual orientation. So, I joined the Senate at the same time as some other new senators who didn't think the old ways were necessarily the right ways. And we started an organizing campaign and did something that was really outside the so-called gentlemen's agreements of the Senate. We went into the districts of people who were blocking this bill and leafleted and told their constituents what they were doing. And the bill is overwhelmingly popular. When you explain it to people in most parts of New York State, we have had flyers that said, stop the violence, not the legislation. We hit the Long Island Railroad, and within a week of our campaign, they brought the bill to the floor, and we passed it, first bill in history to recognize the existence and the rights of gay and lesbian New Yorkers. And again, it's important to recognize how the short time it's taken us to make so much progress, and also reflect on how bad the laws were As of 2002, we had no civil rights law protecting gay and lesbian New Yorkers against discrimination. We ran candidates in the 2002 elections on that issue, elected a group of new members of both the Senate and the Assembly. Again, the Assembly was our problem. They passed it 10 years in a row. And in a special session right after the election, we passed the Sexual Orientation Non-Discrimination Act, making it illegal to fire someone or to evict someone just because of their sexual orientation. And 8 years later, we actually were able to bring for the first time, a marriage equality bill to the floor of the Senate. Now, we have, it failed. And for those of you who were there, and I know there are a lot of people here who were actually involved and were there, it was a brutal day. But I have to say that it was a very important day and a very important step, because we made people go on the record, and in the 2010 election, we elected 5 new pro-marriage equality candidates. This was one of the great organizing efforts that I have been a part of. And we then worked to bring the bill to the floor. And in 2011, we became the largest state to adopt marriage equality and the first state to pass marriage equality through a Republican-controlled chamber. All of the lawyers involved were New York County lawyers. My friend Robbie Kaplan is here, and we're proud to have our office supporting her efforts through our amicus briefs, but believe me, the legislation was drafted by New York County lawyers, the votes were counted by New York County lawyers, and the tradition of this bar continues in our work on these issues. So, the law has been challenged in court. I'm proud to say my office has defended it successfully against all challenges. We had a significant victory on October 23rd. Our great State Court of Appeals, and we are here with our great Chief Judge, my partner in justice and personal hero, Jonathan Lippman, and other distinguished members of that court. Our great Court of Appeals said you're not going to get a hearing here, and everything was set in New York. Now, the next challenge is that our gay and lesbian married couples in New York do not enjoy all the same rights as straight married couples because of federal law. So we are very proud of the fact, and she's being honored tonight, that Robbie Kaplan brought the case in Windsor v. United States. My office filed an amicus brief, and Robbie did a brilliant job, successfully argued the case, and as you know, it's going to the U.S. Supreme Court. We argued on our part, and this is, I think, something that is very important, and I think it is a part of why I think we'll succeed in the Supreme Court, that this DOMA, this federal legislation, doesn't just discriminate against people, it discriminates among the states. States have a long-standing authority to regulate marriage. That is something that there's no dispute about. And because the federal legislation is an unparalleled intrusion into the state regulation of marriage, we argued successfully that it should be subject to heightened scrutiny. The Second Circuit agreed, and they also noted that DOMA's defenders did not establish any federal interest in the rejection of same-sex marriages. So I think that this forms the framework for victory in the Supreme Court, and I look forward to those arguments. The Supreme Court has also accepted a case challenging Proposition 8, California's ban on same-sex marriage. That case, of course, is being handled by David Boyce and another New York County lawyer. I'm optimistic that we will prevail in both cases, but setting that aside, and for you who are lawyers who have the choice of what kinds of causes you dedicate your time to when you're not just billing hours, I think it is important to recognize that the movement for LGBT equality has to succeed, that any of these discriminatory laws will not remain the law of the land for very long, because this is fundamental to who we are as lawyers and who we are as Americans. We have a tradition in this country of working every generation to make the commitment that was made at the beginning, the founding of our republic, ever more true. When Thomas Jefferson said, we hold these truths to be self-evident, that all men are created equal, we know it wasn't true on the ground, that African Americans were still in bondage, women didn't have many rights at all, property owners enjoyed rights that others didn't, Jews, Catholics, and adherents to other creeds were subject to discrimination. But through our history, men and women, and many great lawyers have struggled and organized to make our country more true to the founding principles. And our generation is now called, and this is our fight. The fight for LGBT equality comes to us, and I'm confident that we will prevail and participate in this great American tradition. In my office, we talk a lot about equal justice under law, one set of rules for everybody. I know that we will succeed. I'm confident that we will succeed. I know that before my time here is done, this will be the law all over the United States. But it is because of the hard work of some of the people you're honoring here, and because of a lot of great New York County lawyers, lawyers all over America, and activists and organizers that we are making this progress. I'm honored to be in this audience, in this group with a tradition of embracing equality and justice for all, to celebrate the ongoing struggle that we are called to right now to further that quintessentially American ideal. Thank you very much, ladies and gentlemen.
Thank you, Eric, for those thoughtful and inspiring remarks. Before we begin dinner, we have a presentation that is a surprise. We have not mentioned this presentation in the program for this evening, and the recipient does not know that it is coming. It is a presentation that is in many ways happy for all of us, but in one way it is sad. We are happy that a person that we have loved and respected for many years will continue to be an important part of the legal community in New York, but we are sad that she will no longer be a judge. We are sad that Judge Carmen Beauchamp-Separak is now 70 years of age, the age of the age of constitutional civility for Court of Appeals judges, and that she must therefore retire in only 20 more days. In recognition of her 34 years of distinguished and dedicated judicial service, and with enormous respect and affection, NYCLA would like to present a plaque to you. Judge Separak, please come to the podium. The plaque reads, presented to Honorable Carmen Beauchamp-Separak, Senior Associate Judge of the New York State Court of Appeals, in recognition and appreciation of 34 years of distinguished and dedicated judicial service.
say thank you. But it's been a wonderful run, and I'm not going very far away. I'm still a part of the legal community of New York County. So thank you for your support and encouragement over the years, and I look forward to continuing working with you. Thank you so much.
We now invite you to enjoy your dinner and to look forward to the rest of our program at the conclusion of dinner. Before we have dinner, I do want to thank the sponsors of NYCLA's 98th Annual Dinner. Our platinum sponsors are Arnold & Porter, Cravath, Swain & Moore, Hughes, Hubbard & Reed, Paul Weiss, Rifkin, Wharton & Garrison, and Skadden, Slate, Meager & Flom. Our silver sponsors are Cleary, Gottlieb, Steen and Hamilton, Greenberg and Traurig, Kelly, Bryan, Warren, Latham and Watkins, Mayor Brad, Sullivan and Cromwell, and Winston and Strawn. And our crystal sponsors are Davis, Polk and Wardwell, Getnick and Getnick, Orrick, Harrington and Sutcliffe, and Proskauer Rose. I also want to thank my dinner co-chair, Michelle Coleman Mays. I will introduce Michelle Mays more formally after dinner. In addition, I want to thank Stephen C. Lazard, the chair of NYCLA's LGBT Issues Committee, who has made exceptional contributions